That's 15-0.
Pushing your luck there.
Is this your 26?
All right, 1542.
There's a substitute on that one.
Is there a motion to adopt the substitute? It's been moved and seconded to adopt the substitute. All in favor signify by saying aye. Aye. All opposed. Substitutes before us.
Okay, this is another one that Poverty Law Center requested. It has to, again, to do with no fault. We're not, actually doesn't have to, yeah, no fault divorces. As we've limited to no fault divorces. Back in 2017, we passed legislation. It has to do with the waiver of filing fees for divorces. Back in 2017, we changed the code to say that you could get your filing fees waived if you would otherwise qualify for court-appointed counsel in a criminal case. And that's created some inconsistent practices across the Commonwealth in terms of how that's processed. Some clerks ask more questions than others, and others, if you say you're receiving federal or you're receiving government benefits, that's sufficient. This substitute just makes clear that if you're proceeding with a no-fault divorce and the person certifies that they are receiving public benefits, that there's no more questions asked in terms of getting the waived the $49 filing fee. So hopefully that'll, again, expedite the filing process and, again, encourage more people to bring these things. And right now, instead of the clerk asking some people 20 questions about their income and assets and whatever, if they just certify they're receiving benefits, they can file without a filing fee, which is, I think, what our original intent was.
Yeah, and before getting into the substance of the bill, line 22 or 2122 requires a certification of receipt of such benefits before a notary or clerk. Not seen that language before. Shouldn't it be under oath or under penalty of perjury or appropriate language?
I think there's some form, Valerie can explain, I think there's some form that they have to do which has that language in it,
But isn't it under oath?
She would know better than me. Go ahead.
Mr. Chairman, most courts have the person sign an affidavit anyway when they're, so that would be under oath.
But if you want to add under oath, it's fine.
But that's fine as well.
Mr. Chairman, I agree with the under oath, but I have a separate question I want to ask Senator Servo.
All right, so strike line 22 and insert under oath?
Mr. Chairman, traditionally in the past, when we have made things under oath or under penalty of perjury, then they get a corrections impact because the penalty for perjury is a classified felony.
Well, and I understand that, but, you know, we're not going to create new language just to avoid a corrections impact. I mean, I don't think that's appropriate. I think if it has I mean, if we're going to put that language in and require them to do it under oath, they need to do it under oath. So is there a motion to make that amendment?
So moved.
All right, the amendment is moved and seconded. All in favor signify by saying aye. Aye. All opposed? All right.
Mr. Chairman, my question for Senator Servo is it's the not rebuttable language. So
what?
if I am watching the Powerball come back and I see Joe Smith won the $80 million Powerball, and the next day they come in with their no-fault divorce decree and say, well, I'm receiving public assistance, and right now we still require them to tell us about they're receiving lottery funds. Why is the not rebuttable language there needed?
Just point out, first of all, that we said that Powerball winners can ask their names be secret from now on. I voted against that.
But today they're public, and that's why I'm pointing it out. So isn't the same argument the one you made on the floor that if there's something else, why would you want that not to be rebuttable? I don't have a problem with the other.
So,
but I mean,
and to follow on with that, I mean, come on. I mean, in 99.99% of the cases, isn't it adequate to say that there is a presumption? I mean, who's going to rebut that presumption?
I think that's what the current, Mr.
So
Dre,
this
correct me, I believe that's what current law is by referring to 19.2159, which is what's caused these inconsistent practices with some clerks requiring you to prove your income and assets and everything else to save $49.
But
which-
doesn't this do that, still provides that framework for how you establish that presumption?
Does what provide that framework?
Saying that if they're a current recipient of state or federally funded public assistance benefits.
I think on this sub, all you'd have to do is certify it, and then that ends the inquiry. If there's
Yeah, I
no
know,
pers-
but to
rebuttal.
Senator McDougal's concern, maybe there is, I mean, and this is not, this isn't going to change the rotation of the earth, but, I mean, isn't there going to be, doesn't that, protect the cases that you're concerned about, but provide that outlet for cases in which there truly is some fair, legitimate reason to dispute that the person is indigent?
I would defer to Mr. Dre on that.
Let me just speak to that for
He
1
lives
minute. I
this
mean,
every day.
we're again talking about access to justice. And what I found in doing these cases over the last 3 or 4 years is that different courts either automatically approve it if you're getting these benefits, or because it's been tied to the criminal statute, they drill down on it. Or third, we've had courts that ask us to actually move the case to another jurisdiction. They will not waive fees even if someone is receiving these benefits. So again, my reaction is if you want to encourage access to justice, more people to help people get access to justice, worrying about a $42 filing fee, it just doesn't merit,
Mr. Chairman.
Senator McDougal.
leaving it rebuttable.
What, Mr. Chairman, then we should say, if you receive these benefits, you shall not pay the fine, the fee, instead of rebuttable. There's a myriad of situations. The lottery, somebody is owing public assistance and they get a docketed personal injury claim, and all of a sudden they decide that they don't want the person that they're married to have some access
If they're
to.
getting these benefits.
But
they're
Mr.
not-
Chairman,
don't pay
so
the cost, yeah.
I don't understand why we wouldn't say the presumption, leave and have that. It doesn't, either you're going to say, if you're getting the benefit, you never do it, or create a actual presumption, not a, I don't know.
All right, so do you want to make a motion to amend?
Make it rebuttal?
Make a reb- I think we've got the parameters of the issue.
I got maybe a better fix, Mr. Chairman.
Do tell.
My amendment would be on line 18, strike provided that and say, except in the case of a no-fault divorce proceeding under such and such, where the person who is a current recipient of a state or federally funded public assistance program for the indigent, period. That brings in the rebuttability, I suppose, but if the person can prove that, then they don't have to go through the factors under subsection B of 19.2-159.
It sounds like there's agreement about rebuttable. It's just a question of where you put it in the sentence. So I would think Kristen could figure that out if that's the committee's will.
Can you figure it out, Kristen?
I did not get Senator Edwards' amendment.
His amendment was strike provided that,
Say, except.
put except in the case of, so basically, the court shall, never mind. I don't think that makes sense. I don't think that works. Right. All right. Anybody have an amendment, or shall we move on the bill?
I'm going to move to strike, shall not be rebuttable.
All right. So motion, is there a second? It's been moved and seconded to strike shall not be rebuttable. All in favor of that amendment signify by saying aye. Aye. All opposed? All right, that amendment is made. The bill is before us. It's been moved and seconded. The bill
Mr.
be
Chair,
reported.
I'm sorry, can
I'm
we
sorry.
just hold up for a second? So it would read, provided that In the case of a no-fault divorce proceeding, the presumption that a person who is a current recipient of state or
There shall
federal...
be a presumption.
There shall be a presumption.
Right.
That's what your motion was, correct? Okay.
Got it, thank you.
All right. There's a motion to report the bill as amended. The roll is open. Senator Servell, you're on a roll.
Maybe I should be in favor of bill limits. I don't know.
We want to keep you busy during the remainder of session.
Mr. Chairman, I heard that Senator Servell is going to support the bill limit of 15 next year.
They'll be really good bills. All right.
1544.
Senate Bill 1544.
This is a bill you all saw last year, and there's absolutely no changes to it. So
What do
just
we
to remind
do?
everybody what it does.